So it's not the kind of thing we usually might discuss here, but it's an interesting story, and it seemed like pretty good time to be talking about this. There is a piece in the Globe and Mail dealing with estate planning, but the part that really stood out to me was the part where our next guest, his name is Tim Cestnick, discusses things that you might not consider, or perhaps you should be considering higher on your list if and when it comes time to prepare, when it comes time for estate planning. And they are what are called the 3Ds. So let's find out more. Tim Cestnick is a chartered professional accountant, co-founder and CEO of Our Family Office, Inc. in Toronto. Mr. Cestnick, thanks for being here. Appreciate the time. Can I start with the 3D elements here, which I found really interesting, including I'm going to get to document in a sec, but the part about discuss, why is that so important and with who?
Well, that's a good question. And, it's something that, documenting, which is another D, is something we all do really well. We prepare wills or mandates, and we make sure our paperwork is in order. But quite often parents forget to discuss these things with their kids. Now, there's a time and a place and an age at which it probably makes good sense. But you don't want to hide your estate plans from your kids or your heirs. In most cases, the real question isn't whether to talk to them, but when and how and what to share. So, simply handing over a copy of your will is not really a substitute for a good conversation with them.
It's funny as you say that. I can't help but think that with the idea of discussing, maybe some people think discussing would be the worst thing you can do because all that does is potentially create a situation where, you have one sibling who doesn't care or doesn't like what you did, and you set up sort of a confrontation more than anything else.
Well, the confrontation, if it's going to be there, first of all, it's your money. If you're the parent, it's your decision, and you're probably better off having a conversation with kids and explaining why you're deciding what you're deciding, even if you think it's not going to sit well with everybody. Because if you're gone and some of the kids aren't happy, you'd hope that no one would take legal action, but it does happen pretty regularly. So at least if you've explained your rationale, why you're doing things, your intention, it can actually avoid hard feelings and can actually lead people to accept everything when you're not around.
I think this is very funny because as you say this, I'm thinking, you know what? If you don't discuss it and eventually you pass away, you don't care because they can work that out on their own. You're no longer involved. So you've removed yourself from the equation. But I appreciate that's not what you're supposed to be doing. But I bet there are people who think, let them worry about this when I'm gone. I don't want to worry about it now. I don't want to start the trouble now if there's going to be any.
But all you need to do is talk to a few lawyers and accountants about horror stories they've heard about estates that went wrong. And it almost always comes down to just lack of communication from parents before they left,
okay.
Before they were gone.
Can I touch on that, though? When you talk about that after the fact, right? Let's say you've left a will. Your plans are pretty well laid out. When you talk about, fights that come up after the fact, if you have a notarized will and it's legitimate and everything's there, what is there to contest?
Well, that's a good question. Sometimes it's not about that. Sometimes it's about, parents can say in their will, divide everything three ways. If you had three children, for example, divide everything three ways. Everybody gets an equal amount. But what happens if the biggest asset they own is a cottage or second piece of real estate, and now somebody in the family wants to keep the cottage. The other two say, well, how do we split that three ways? And, the plan is not clear. And then if one buys the other two out, how do you agree on a valuation? All kinds of things can come up depending on what you own. If everything you own was just cash in the bank, it's easy to divide three ways. But the more complicated your affairs are, maybe the more real estate you have, or if you have a private business or other things, the more you really need to plan ahead and talk to your heirs about what's going to happen and get their input. Doesn't mean you have to listen to them, but get them to provide their thinking and make sure everyone's clear on what plan's going to happen, what's going to take place when you're gone.
Okay, fair enough. If I can go back, I don't want to run out of time. Let me start with the top one. You mentioned document. What is it you should be documenting here exactly?
So there are three key things you need to document. First is having a will, because if you die without a will, then the province steps in and dictates who gets what. And that's not usually very good, because it's not only is it, it's probably not who you want to get the assets, but also you can end up paying more tax than you should. Because, leaving things to a surviving spouse, for example, is the easiest way to avoid tax. But that won't happen if you don't have a will. Second document would be mandates or powers of attorney, or what we call, or mandates in Quebec, which are really instructions for what not your executor, but your attorney should do if you become incapable of making decisions for yourself. So you can't make health decisions, or you can't make decisions about your finances. Someone else has to decide for you. That just gives somebody else the power to do that, and you can name that person. And then the last document I think is really valuable. It's not a legally binding document, but it's what we call a letter of wishes. It's where you provide all kinds of important information to your family if something were to happen to you. So it can be things like a list of the assets that you own, or a net worth statement, or it could be maybe instructions about your funeral arrangements, or personal messages you want to leave to family, or guidance you want to give to trustees or guardians. You name someone to look after your kids. Well, is there anything you want to say to those people about how to raise your kids? It's these kinds of things that are really important. It's not in a will. And so having a letter of wishes lets you spell out all kinds of things like that that can be really valuable to people who survive you.
Okay, the last thing I would bring up, and I'm pretty sure I've seen ads for this, right? People may say, well, it's expensive to get this done, get a lawyer, notary, whatever. There are people who offer to do this for you online. Now, I appreciate you're in the business. How good an idea or bad an idea is that to get this done online?
Well, I think a will that you can do online yourself is better than not having a will. It's better than dying intestate without a will. But the more complicated your affairs are, if you've got a business, you have some real estate other than just your home, I think it'd be really wise to get a lawyer involved to help draft these things, because you can never cover off all the little nuances that you might need to be worried about through an online app or some kind of app that's going to prepare your will. Again, better than nothing, but the more complicated your affairs are, it's worth paying something to have a lawyer to draft this for you properly.
This is kind of a you get what you pay for scenario.
Yeah, exactly.
Okay. And the last thing you mentioned is distribute, which is about what?
So there's different ways of actually distributing your assets to the next generation, to your heirs. One is through naming beneficiaries. So on your life insurance policies or pensions or RRSPs or tax-free savings accounts, those kinds of accounts, you can name beneficiaries. You can also do it through joint ownership, where you jointly own an asset with somebody else. So when you pass away, the asset automatically goes to the other person. You can do this through more complicated means. If you have a business, you might have a shareholders agreement, which talks about who gets the shares of your company if something happens to you. And then, of course, there's through your will, which is the most common document. It needs to be prepared as we talked about. And also keep in mind, too, that fair doesn't always mean equal. So, if you're not leaving everybody in your family an equal amount, your kids, that's especially a case where you want to have a conversation ahead of time. And the last thing is in terms of distributing assets, you can also give some stuff away during your lifetime as well. You might want to see your kids benefit from some of these things you're going to give them, maybe while you're still alive. That can be a pretty enjoyable thing too.
Last thing before we run out of time, if I can, what's the mistake that you see most people make outside of not having the will? What would be the next most common mistake?
Well, not updating their will at critical times. So for example, you should be looking at your will at least every 5 years to see if it needs to be revised. And it probably does something needs to be changed every 5 or 6 years, probably. And especially if you go through a marriage breakdown, you go through a divorce or a separation, or maybe there's been a birth in the family or a death in the family, major events in the family like that usually causes a requirement to change your will, right. And people forget about doing that all the time. All
right. Good advice. Thank you so much. Very much appreciate your time.
Yep. Thanks, Aaron.
Take good care. If you want to read that article, by the way, it's in the Globe and Mail. Tim Cestnick, chartered professional accountant, with some good advice there, I think. And to what he said, yeah, I know there are people now, services that provide this kind of stuff, like online. But as I said, it's one of those situations, you spend a couple bucks more, maybe it's a better idea, depending.